Say hello. Come on in. Say hello. Come on in. Say hello. Come on in. Say hello. Hello, Miss Ayefeso. How are you? Thank you so much for always joining. I really do appreciate it. Thank you for the support. God bless you. God bless you. God bless you. Come on in, everybody. Come on in. Come on in. Say hello. Say hello. Let's see. Olori. Olori OA. Welcome, welcome. Happy Thursday to you as well. Bolu Arctic. Welcome. Soul Seekers Music Entertainment. Welcome. Olamide Silver. Mike Thomas. Good evening. How are you, Mr. Thomas? Hi, everybody. Hello, TikTok family. Hi, Facebook, YouTube. Thank you. Thank you, Mr. Professor. Appreciate that. Thank God. God be praised. Happy Thursday, everybody. This week went pretty fast. I know I say that quite often, but for real, this week went like somebody snapped their fingers and was like, okay, let's hurry up. Let's get into July. Like June just ran. June just ran. Like June just ran. 100 meters relay, whatever. It just went like that. This was no marathon. No, you just went down. Like June was like, I'm not sticking around for y'all. Just y'all can leave me alone. But anyway, hi everyone. Come on in. Happy Thursday. I hope y'all have had a blessed week so far. If you're just joining us for this first time, say hello. Let us know where you're joining in from. What state, what city. I have the concoction that I mixed up. Yeah, I have to make my own stuff. What state, what city, what country, actually, because we have people joining from other countries. Welcome in. I hope you all have had a wonderful week so far. So let's give it some time before we start. It's like, who is this lady? It's me. Hello, Zach. How are you? Hello, Mr. Jude. Hey, Michael. How are you? Welcome in, everybody. Welcome. It's been a great day. It's been a favorite day. We thank God. It's like, since no man look for me, because I went to court. I wear more clothes. If you may not consider this more clothes, but for me, yeah, it's sleeveless, but it's still a whole lot of. You have courts, but you got to be professional and all. Anyway, welcome, everybody. This is Attorney 𝒊𝒎𝒎𝒊𝒈𝒓𝒂𝒏𝒕, immigration attorney based in Alabama, representing immigration clients in all 50 states. Hey, Epic Movement birthday mate. I actually was talking to someone about her birthday. So her birthday is actually also August 21st. Well, I was talking to my sister-in-law. I should be very specific about her mom's birthday is August 21st. So she's turning 70. You went without me? Really? That's how it is now? Seriously? I'm not even kidding you. I was thinking about that because, like, when was the last time I went? They haven't been back to the Bahamas since Olive Beauty Empire since March 2023 is about time I go back. But I know a lot. I know Luakbo. Welcome in. Yeah, but I know you. But I didn't see the email where you said we should go ahead. So let's start. Do you want to wait till you get back in the country? Hey, Ellen, Senator Sanctuary. Do you want to wait till you get back in the country? What do you want to do, Epic Movements? Let me know. Ready whenever you are. You're the one. It's the ball is in your court, so you can bring your mama here. Bring me the sky juice if you can bring. I'm not even kidding. If you can bring it. Because we don't know what TSA is doing now, I would send you kisses from here. But let's get yesterday's. Are you going to be filing for your mom? Any intention of filing for mom? I think you should. So I think she can come in at anytime she wants. But anyway, once again, this is Attorney 𝒊𝒎𝒎𝒊𝒈𝒓𝒂𝒏𝒕. I'm an immigration attorney based in Alabama, representing immigration clients in all 50 states. If you've got an immigration case, if it's a case now, thank you. That's what I still have on. You know, that's if I wear formal dresses like that, I have court dates. Because, you got to look like you're a lawyer. Because normally I don't wear, people say I don't wear a lot of clothes. To each their own. and no sleep over that. What can I say? But so let's get started, because you remember, you guys still wait for the interview, oath ceremony, all of that good stuff. So yeah, let's get started. So I'll wait to hear back from you when you get in. We can start before you can get in, but email me and let me know so we can get started. I'm an immigration attorney. My office is based in Alabama, but we represent immigration clients in all 50 states. So it doesn't matter, Gen Z attorney. Listen, whatever, Z, X, Y, J. I do my own stuff. I'm the attorney who wears a red dress into court, like bright red, like brighter than mine. Okay, my lipstick, and everybody's in black. Yeah, that's me. It's not. I'm not an attention seeker. That's we're far from it. But if you're not, hey, I'm Muslimi. I think if you're Caribbean, you're African. We're raised to command a room when you go in. It doesn't matter what anybody else is wearing. You command it. And I can't even tell how many times people tell me, like, I walk into the room like I own it. Nothing intentional. It's just like, that's how we're raised. What can we say? What can we say? But anyway, contact information is 334-341. It's just like, wait, listen, and then that part too, being Leo, it's a combination of everything. It's a lot, but hey, and it's not right. Ethic movement. It's not anything arrogance or intention. It's just, this is what I feel like doing. And hey, if it catches your attention, great. If it doesn't, that's okay. 334-341-4475, info@olalayalawfirm.com. That is our contact information, but the contact information is on all of our pages. So just go on TikTok, you see it on our page, Instagram in our bio, Facebook and YouTube is scrolling across the screen. We'll be more than happy to help you with your immigration case. So let us know how we can help you with that and walk this journey with you. Exactly. So subscribe, like, follow, share, Facebook, Instagram, TikTok, LinkedIn, YouTube, WhatsApp @Olaleye Let's grow our immigrant community, especially now more than ever. The support system we need for one another now is nothing like we've ever seen before, but the stronger we are together. That's one thing I believe. But anyway, so that's that about introduction. Let's talk immigration. What we're talking about tonight. So real quick, obviously, unless you're living on the rock, we see things on the news and all that. And especially when it comes to people being detained, an interview, or one thing we're seeing a huge trend on is issuance of notice to appear in immigration court. So we're talking about denial and NTA. So basically, in a nutshell, if your case is denied, should you expect USCIS to send you a notice to appear in immigration court and then place you in deportation proceedings? So let's talk about that. If you've got questions, put your questions in the comment section, and we will get to as many questions as possible at the end of the discussion. So what we're seeing if you have if you follow USCIS or DHS on their social media platforms, you would see recently where they have this consistent post about the number of the thousands of people that they're really proud, thousands of people they have put in removal proceedings in the last 4 months, 26,000 or something. That's the time they made the post. So that's their their badge of honor kind of thing. So that yeah. So if your case gets denied, thanks, Miss Inner Sanctuary, not Nigerian solution. So this lady she's got those sentences that she just pulls them out from nowhere. I wasn't even thinking it. So with all the bragging you and USCIS shouldn't be. They need to have like 200 seats. Just mind their own darn business and leave enforcement to the people who are actually hired to do enforcement. But anyway, they've interjected themselves in that. So here we have it. If your case is now denied by USCIS, should you expect to get an NTA, notice to appear in immigration court, That's number one. Should you still expect to get a notice of appearance in immigration court if you have a pending application? Say, for instance, your case gets denied. It says you got 33 days to leave the country. You don't leave the country. You decide, I'm going to refile. Now I have a new petition. I have a new I-485 application. Am I still subject to them issuing a notice to appear in immigration court to me and being placed in removal proceedings? Short answer, yes. So let's explain that. It used to be. Now, let me start with the INA. The policy or the goal that's been set up by USCIS, because they released the policy, I think it was a month or 2 months ago, where they stated that if we deny your case, whatever the application, the petition, whatever the case may be, we are going to issue a notice to European Immigration Court and place you in removal proceedings. So if you have a pending case, however, if you've got like a non-immigrant status that is a fallback, then obviously you don't get placed in deportation. So an example would be if someone else is on an F1 visa and then they get married, they file an adjustment of status application. For whatever reason, USCIS doesn't believe that their marriage was a genuine marriage. They deny that case. As long as that immigrant has maintained the F1 status and they did not, let it go, they didn't get out of status, is still in school, service account is active. Even if that AOS application is denied, then because they have a valid status, they cannot be placed in removal proceedings unless they violate that status. But if you do not have a status, and please keep in mind that a pending asylum application is not a valid status. It is an authorized stay. And that's the one thing that comes up with so many of my consults, where people get to. I had a lady who was convinced that I didn't know what I was saying, which is fine. Nobody knows everything. But now she's back to my firm and she's not retaining my services. It would have been a better situation if she had listened to me the first time, but here we are. But what happened is she had an employer promise to sponsor her. She's a nurse, and they said they're going to file a scheduler petition on her behalf. She had a pending asylum application. And when the I-140 was approved, she filed the green card application. When the priority date became current, USCIS denied her case solely because she doesn't have any valid non-immigrant status, in spite of a pending asylum application. And I think that kind of like triggered the asylum case, because shortly after that, she was scheduled for an interview. They didn't grant her that, and she was referred to immigration court. So if you don't have a backup status, which, like I just explained, asylum is not a status, it's an authorized stay, and then your case is denied, there is a higher possibility now with this administration that you're going to be placed in removal proceedings. And that's just what we're seeing. And, the policy they released, it's not something they're just making up to be, I want to say to be fair, to be decided, but in reality, let me put it that way, it is part of the Immigration and Nationality Act. It's not a policy they just invented. It's something that's always been part of the INA, where if a case is denied, so the wordings that you have, like for instance, an I-485 gets denied, it would say, at the time you filed this application, you were unlawfully present in the country, yada, yada, yada. You've got 33 days to leave the country, or we may issue you a notice to appear in immigration court. It's not something you see that every single I-485 where the person does not have a valid status has that language. And that's because that's what the law requires them to do. So if you don't live within that time frame, they're supposed to be placed in deportation proceedings, removal proceedings. The thing with the previous administration, however, is that it hasn't been enforced. So it's not like it's a new policy, a new statute. No, it just hasn't been enforced to the extent that these people are enforcing it. It's always been at most of the time when I had NTAs frequently issued, it had to do with I-751 petitions. Sometimes you get that denial or your termination of conditional residency issued with a notice to appear in immigration court. So, but what we're seeing now is if your USCIS denies your case, they're going to issue you a notice to appear in immigration court. The question then is, how quickly is that going to be done? You're hopeful. I was going to say we're hopeful that it won't be as soon, but it will depend. So say, for instance, some people may actually benefit from being referred to immigration court compared to being able to apply for any immigration benefit with USCIS. Example, you file an I-751 petition, you file it based on good fit marriage, but you suffered abuse, good fit marriage, but it's ended in divorce. And USCIS does not accept that you had sufficient good fit evidence, and they conclude that your marriage to the petitioning spouse in the first place was a fraudulent marriage, and we should not have even given the green card, the 2-year green card you have. And then they refer you to immigration court. If they allege that you fraudulently obtained that green card, then there's nothing you're going to file with USCIS that's going to take care of that for you. But you as an I-751 petitioner who finds themselves in that situation, you have the opportunity to actually apply for a 237H waiver in court. Only an immigration judge can grant a 237H. It's called a fraud waiver. So in cases where someone gets an I-751, you file it jointly, you file it separately based on divorce. USCIS denies your case. You now refile your I-751. You file it maybe based on extreme hardship. They come back and they still deny your case based on the fact that they've concluded that your marriage, the underlying marriage, was a sham marriage. You get an opportunity to review your case in court. And you also get an opportunity to apply for a 237H fraud waiver that will take care of the allegation of the fraud and be able to not apply for the 10-year green card. So it's not, NTA is not always bad for everybody. It is very case specific and fact specific as well. But should you expect, is everyone's case that has been denied, as everyone received it, or people who have recently had denied cases, as every one of them received NTAs? No, it's still a flawed system. You know, they can only do so much. They're understaffed anyway, which is good. It's good for us, but it's not good in interviews. But if you get an NTA, it's not going to be the end of the world. They've already said that they're going to be issuing that. They deny an I-130 petition if the beneficiary is here without status. An I-45 application is denied. Even if you withdraw your application, that does not prevent USCIS from still issuing you a notice to appear in immigration court in spite of that. Let me go a step further. Even if you've got a pending I-130 petition and you've got a pending green card application with USCIS, that does not stop them from still placing you in removal proceedings. A pending I-485 authorizes you to stay in the country, but it is not a deterrent to USCIS issuing a notice to appear in immigration court. Why it hasn't been done most of the time in the previous administration is because it's just going to be a waste of time and resources for the U.S. government. We already know with this administration, they really don't care about wasting money. That's one of the expertise. So it is what it is. So if you get a denied petition or application, it is possible right now. There's a high probability that you will be issued a notice to appear in immigration court. Depending on your circumstances, you may be able to use that to your advantage. Or if you've got a pending case with USCIS, you can always go to court and ask the court to, continue your case, or, they're not doing administrative closure anymore for the most part, but you can still request that continuance given so that you have enough time for the new petition to be approved by USCIS and go from there. So it's not going to be the end of the world if you're issuing an NTA. It's actually a policy. It's actually a provision that is included in the Immigration and Nationality Act. So it is the law. This administration is just enforcing that more than any other, because one of their goals is to get as many brown-skinned people out of the country as possible. So that's that in a nutshell. If you have a case where it was denied, you're wondering, if you want to know if you've been issued, because sometimes you may not actually even get any notice. People, someone wasn't Monday. I think it was Monday. I was consulting with someone. And I was like, hey, have you run your number on the UR website to just see maybe there's any NTA has been issued or you're in immigration court? Because based on the fact of her case, I was like, let me check. We checked on Monday, and lo and behold, she has a court hearing scheduled for, I think it's October. Is it October 2025 or 2026? Is October. Hasn't received an NTA, but it was a denied case. Has another case that is pending. But that's another way you can use check to see if you don't get a notice to appear, and you're, especially if you're about to submit a new application, go on the internet, put in EOR case status. It will take you to the page. Put in your alien number. If you have a case with court, it will let you know what court, what judges your next hearing. If you don't do it by going online, there's a toll-free number that you can actually call to get the information about whether or not you are in immigration court. So it just depends. They are issuing the NTAs more now than ever. It's not a new policy. Hey, Miss Sabina. It's not a new policy. It's just being implemented more now than other admins. And that's all sure, people. That's all I got. That's all I got. Okay, let's see. All right, so go to as many questions as possible. We're not going to stay on an hour because it was a long day. I do criminal defense work, and that was what my day was this morning. And then in the afternoon, I had divorce consultations. It's funny because there's one of the clients like, "Can I get divorced tomorrow?" It's like, it's not that fast. I know what it feels like to want to be divorced from somebody you just don't want to stay with. I was like, no, it doesn't work that way. Talking of not working that way, I just remember I have to send him something. Okay, but so it's been a long day. We're just going to get as many questions as possible. Nothing specific to anyone's case. General responses. If you want something that's going to be more tailored towards your case, then you can set up a consultation. We've got 30 minutes, 45 minutes, an hour option. $140, $210, and $265, and we'll be able to strategize and evaluate your case. Okay, all right. I attended my N400 interview in November 2024. No decision yet. Congressman contacted by USCIS still needs 90 days for decision. I have not guilty arrest in 2006, but an N400 interview arrest was disclosed. Okay. So an up now, no decision yet, Congressman. So what's your question? I have about I-45 interview next week. Please, what important documents should I take with me? Your I-45 notice will tell you the documents that need to be taken with you. But if you have an attorney, talk to your attorney because they know about your case and what documents will be relevant to your case. Okay. All right, let's go to TikTok. 254. All right. Withholding of removal, is it safe? So I think Monday, the Supreme Court issued an order. They held that basically, because this administration had petitioned the Supreme Court for an emergency stay on the order of the injunction of a federal federal judge that said that it was unconstitutional or against the Convention and Torture Act to deport immigrants to third-party countries, whether it's safe for them or not. Even if they can be other than deport immigrants to other third-party countries other than the country of their own. So they came back and they actually suspended that injunction. So basically, this administration has been given the green light to continue to deport people to third-party countries. So that brings me to, in relation to your question, is it safe? I can't tell you what is safe or not safe because that, when it comes to case-specific matters, then you're going to have to talk to your lawyer. However, withholding of removal is actually a removal order. You've actually been ordered removed by the judge. The only thing is just that you will not be deported back to that country that you designated as a country of persecution. But withholding of removal involves the fact that the U.S. government is able to deport you to a third-party country. So if they just received a ruling 3 days ago in their favor saying they can do that, and you have a withholding of removal, which is basically an order removal, you're just not going to be removed to the country where you fear persecution, then they can just take the person to Ecuador. So that's basically that right now. That's what we're saying. I hope that explanation helps. Okay, let's see. It's Nadia, and it is almost. It is an idea, and what can we say? I know that my boys are still there because my oldest kid, my 20-year-old, is very introverted. He's coming out of his shyness one step at a time, but he's not like TJ. TJ is like he doesn't know any stranger. TJ's a kid. You tell don't talk to a stranger on the road, and he brings a stranger in. So I guess that's my child. But one of the things I know that I remind my boys about is the importance of when you talk. Hey, Miss Sophia, when you talk to somebody, to look them in the eye, make eye contact. Don't look down. Don't look in the sky. Don't, eye contact. And sorry, this is what I always do to my kids. Whenever they're talking, I'm talking to them, and they're looking their way. It's like right here. So because it's building confidence. It's saying that yes, you've got to. I'm sure you can relate, Miss Sanctuary. Yeah, he's the one who don't talk to stranger. No, the stranger's coming back to your house. Just believe it. Who's the stranger? But why? Okay, let's see. Hi everyone on TikTok. Thank you for joining us. Oh wow, so many people. Thank you. Thank you for taking time. What if it's marriage based that got denied, then you file for asylum to withhold removal due to fear? The fact that you file for asylum does not still prevent them from issuing a notice to European Immigration Court based on that denied case. A lot of people are doing that. The case is denied, and then you go file for asylum. One of my consults today, I told the lady, I was like, because someone told her to go do that. So I'm like, if you hear me say nothing else, hear me loud and clear. This is not the time you want to not just have a backup, like an asylum application, just to file so you can get your work permit and have something that just keeps you here. Because what we're seeing now is those who file their asylum applications later, meaning they're filing now, are the ones who are being scheduled for interviews. If you are filing an asylum application now and you've been in the country for over a year, you don't have any exemptions to you filing for you're not filing. That's the fastest way of you getting into immigration court. So that's all I can say on that issue. Okay, let's see. 1 second. Instagram will be there shortly. Are you saying the fraud waiver can still make you pursue the same case to get a green card? That's what I'm saying. So whenever you file, and using because this is common for me in I-751 cases. So let me use that again. When you file an I-751 petition, and it gets denied, whatever the ground by which you filed gets denied is what the court is going to review. So say, for instance, you filed a good fit marriage, but it's ended in abuse, or good fit marriage ended in divorce. USCIS denies your case based on that because they said it's a sham marriage. Then it's transferred over to the immigration court. However, it does not, you being in immigration court based on a termination of your conditional residence does not mean you cannot file a new I-751 with USCIS. So if you file a new one, so that one is pending with the court. Once a new I-751 is filed, actually the law requires the judge to put a pause on reviewing the one that was initially submitted so that USCIS can now adjudicate the new one that you filed. So you file a new one based on extreme hardship, right? That is also denied because I actually have a recent case where I told her from the beginning, I said, most likely we're going to end up having to file this fraud waiver. Her case is, call me crazy, I don't know. I just thrive with very challenging cases. I don't go to him because why are we going to sleep? Why shall we sleep? Why shall we sleep? But anyway, I told her from the beginning, like most likely the fight is not going to end until we get a court. This is messed up. She's got FOIA record was almost 3,000 pages. So that was one of the very first, because she had a pending I-751. I said, okay, we're going to withdraw that and we're going to file a new one. That's the very first time I have a case where USCIS refused to honor the request to withdraw. Normally, if you withdraw your application, they won't even bat an eye. They'll just tell you, okay, whatever. This time around, they said it in the denial, like, we know that your attorney had requested for this to be withdrawn, but we have decided to use discretion and reject that request because they wanted to have a detailed record of why they believe that 2-year green card was received fraudulently. And so even the extreme hardship basis that we now filed, which does not require good faith, proof of good faith, was denied, not because there wasn't enough evidence of the extreme hardship. It was denied because of the allegation of fraud in the initial I-751 petition. So now she is in court, and that's where the fight really starts, because based on the denial of the extreme hardship, the court now has to review that. But in order for us to be able to get the court to now accept and review and say, yes, this evidence is sufficient, she has to apply for the 237H waiver, fraud waiver in court, first of all. Hopefully the judge grants that. And once that is granted, then the judge can approve the I-751. I hope that helps to put things in perspective. Can citizenship applications take more than 7 months? Yes. How long after approval or you are in the line for oath? It depends on each field office. Girl therapy, that was explained so well. I'm glad. That's why I'm here. People always tell me that I explain things that I didn't. I'm a former adjunct professor of business law. I love teaching. That's just one of my. It's not a hobby. It's my passion. I love to teach. I love explaining stuff. Because for me, the way I've always studied, going through school and all that, I read a text, I read a textbook, whatever the material. And y'all remember, if you schooled in Nigeria, you must, I don't care how old you are, everybody has a jotter. You have to jot things down. You have to summarize. If you can't summarize, then for me, I had to learn, and I still do it till tomorrow. If I'm preparing for a trial, like this morning, the trial I had, looking at all the case, the discovery, but I have to streamline all my points in place and then be able to explain it to myself. If I cannot understand it in non-legal terms, then I know someone else is going to have an issue. So, and I remember my students used to tell me that, the way you break things down, because they'll read the book, I taught business law, and it's not very fun to teach, but it's a whole lot of, intricacies with that. But they're like, okay, the way you give exercises, I know. I was like, okay, that's, I just love teaching. Case denied based on sham marriage. They don't believe there was enough evidence. Can one file a waiver? You may be better off just seeing an attorney just to evaluate your case. Hey, Miss Zoe, how are you? Okay, let's see. Does USCIS confirm divorce decree before approving EAD and travel document for EB1A? Why would your divorce decree be submitted to start with? But that's not a requirement for. What does the divorce decree have to do with EB1A? Okay. Can one submit a customary divorce document after submitting the federal high court document? No, unless you are not telling them that, oh, by the way, not only did I have a statutory marriage, I also had a customary marriage, and here it is. And then you're going to open up a whole can of worms that you should not open. A customary divorce document does not dissolve a registry marriage. So if you're trying to use it in lieu of the high court documents, you can't do that. The only thing that would make sense is saying that you had it. So why you, like I say, you ain't broke, don't fix it. Let's make announcement. Look, you're being questioned. Yeah, Mr. Idris, you're being questioned. Let's see. What does it mean when they say your evidence meets the requirement, but decision hasn't been made? Exactly what you just typed is what they mean. You sound like you went to OAU. What do people who sound like OAU, who went to OAU, sound like? Okay. If they state it's sham marriage and you annul the marriage, does that clear it? No, that's a 204C permanent bar. Permanent bar. I have a client in case we just submitted an appeal. An appeal on the I-130 went out this morning through FedEx. It's a stepchild filing for a stepmother. The initial annoyed we got was insufficient evidence of the qualifying relationship. We knocked that out of the park. We're like, okay, yeah, we got this. And then USCI sent yet another notice of intent to deny. And then they went to town with it. So long story short, that I-130 was denied, not because there wasn't sufficient evidence, because we proved that. It was denied solely because the stepmother was married to, had someone she's still married to. He filed for her initially. And when the son when he became a citizen, they decided to withdraw that and now go the route of child filing for parent. But even though the qualifying relationship has been proven, USCI has denied the case solely on the ground that marriage he had with the American spouse, they had concluded it was a sham marriage. And because a 204C affects any other petition you file, then that means the I-130, the stepchild filed, even though the evidence was just great, but it's the approval of that I-130 is barred by this 204C allegation. So whether you annul a marriage or you divorce the person or even file a completely different category like they did, if they make a sham marriage allegation, that's it. You're not, the person cannot. Yeah, so that's why sometimes in situations like that, sometimes the fraud waiver may be that person's best option if they are now referred to immigration court. Okay. Alrighty. Why is it taking so long to have receipt from renewal? Oh, wow, it's taking forever. It's ridiculous. We got a series of receipt notices today. We're still getting receipt notices for cases filed February and March. We don't have anything about it. Any of our cases are filed in April, May, and June. No receipt notice from Nebraska Service Center. That's what we're seeing. And I have a client who is almost going to lose her job because the employer says she has to produce at the very least a copy of the receipt notice. We can't do anything. Yeah. I was divorced before my 2 years green card expired. I filed a waiver since 2023. Not heard anything. What's your question? What's the risk of not responding to a note of sham marriage? The risk is that they will make a conclusion that it's a sham marriage, and you may have a notice to appear immigration court issued to you shortly after that. After medical, what next? Your case will be adjudicated. Okay. Can one travel to Hawaii? Wait, anything about travel, direct those questions to your attorney or sit down with one to be sure that you can travel safely. All righty, let's see. Is VAWA application transferable from one immigration attorney to another? You can transfer any kind of case from one law firm to another. I joined the U.S. Army. I'm going to file for citizenship through that. I would like to apply for I-130 for my siblings. Can the process be faster? No. Siblings cases are taking no less than 15 years. Hello, Mr. Emeka. The big, beautiful bill. Let's just leave that alone. Was detained now in immigration court, pending I-130, NT in September, but wife is making so hard, has moved out of the house, saying hubby is deadbeat and not giving documents to help the case. So what's your question? Olu, what's your question? Help me out with asking questions, y'all, not just, absolutely, you're welcome. Not just making statements. Okay, let's see. What's it all about? I can feel my eyes getting heavy. I'm telling you so. Even my voice, yeah. Let's see Instagram and then we can get up. Okay. Thanks, Ms. Sanctuary. I was being very formal and very lawyerly today because I'm always in the rompers or I wear a lot of joggers and sleeveless. But I behave myself when it's time to go to court. Leo babies have entered the group chat. Yes, we have. I can file for both parents, correct? Absolutely, epic movements. You can do that at the same time. Absolutely. So let's get started and get you that, and so we can start their process. Not Nigerian Television Authority. Okay. All right. Let's see. Hello, Miss Abena. How are you? It's good to have you back. We missed you. Let's see. We missed you. I'm telling you. If my passport is expired, can I go for fingerprinting? If you're talking about USCI's fingerprint appointment, yes, just take the expired passport with you. Oh, and talking of expired passport, this is what I've been telling my VAR clients that were just filing their VAR cases. I am concerned, especially for those who don't have valid IDs. So, for instance, I have some VAR clients that have asylum case pending, or they had a valid ID before the case was denied, whatever the case may be. But there's some people who've never filed anything, so they don't have nothing but their unexpired passport, or they don't even have a passport. If you find yourself in a situation like that, what I'm telling my clients to do is go on Amazon, so for your VAR case, because you have to do your FBI background check if you can get a police clearance letter. So for FBI background check, normally you go to the participating post office to get your prints done, and they can all do it. But with what is going on in the country now, rather my clients actually do their own prints themselves. It's very, very easy to do. The kit is very easy to get on Amazon. For those of my clients who are actually in Alabama, we've had them come into the office and we'll do it for them, and then they mail it to the FBI office. And also that's another way you can get your fingerprinting done for your VAR case, is to get the fingerprinting kit and make sure someone helps you mail it out, and they'll mail you your results, so you don't have to deal with the anxiety of someone calling ICE on you. Last thing first, yes, that's what they're back to. They haven't announced that, but that's what we're seeing. Absolutely. If an asylum case was administratively closed and then filed for U visa and still pending, I think I know who this is a person at risk of NTA, or just hope the U visa is approved? There's no NTA because you said your asylum case is administratively closed. Isn't that administratively closed in court? Right? Or wait, who administratively closed it? USCI's admin closure usually happens in court. So if you've already been in court, you've already been issued an NTA, unless you're talking of USCI's. If you got an RFE for VAL after 3.5 years, asking for more good faith and extreme battery evidence, even though you sent all of you promised, what do you believe could be done in such a case? Resend everything. So thanks for bringing that up. We're seeing, and I thought it was, I had to ask some of my colleagues, we're seeing this BS, excuse my French, come with VAR cases. Something is going on that I think my association may end up filing a lawsuit. There's within the last 30 days, they start sending the same RFE, templated RFE to VAR petitioners, including even if they had sent you a detailed RFE for the same issues, people are getting, and to include some of my clients, getting duplicated RFEs. But this time around, rather than actually specify what is insufficient, they just check marking a place. So it's everybody's getting the same thing. Nothing specific to your case in the sense of, okay, this is why we feel that your good faith evidence wasn't sufficient. Nothing. They just put in an X on what applies to you, and that's it. So it's the round of craziness we're dealing with now. So you're not alone. So for instance, there's a case that they sent us an RFE. The only thing on that RFE is good moral character. And I'm thinking, we already, have an FBI background check that was done. My client actually did police clearance letter because they lived in Irving, Texas throughout. Good moral character letters, photos of his charity work and all that. So I'm like, okay, he's never been in trouble, no criminal record. So what part of that did you guys not see in that? So that's what you're going to have to do. Some people are getting that. And so you're not alone if you feel like, okay, this is not making any sense. It is not making sense for us as attorneys as well. If an I-130 was approved 6 months ago and yet the I-485 is still pending, can one travel with an AP for emergency purpose? Anything about travel? Ask your attorney. Let's see. Closed in court. So you're already in court. There's no NTA to be issued. You're already the reason why you are in court is because an NTA was issued against you. That's why you're in court to start with. Okay. Can they apply for VAWA or cancellation removal? She keeps saying he should be taken back home because he doesn't have a job, but she isn't giving documents help. Sit down with the lawyer. Or sit down with the lawyer to figure out if it's best for you to convert to a VAWA case. All right, I think that will be. Is interview required as when applicants for filing for adjustment of status? Most likely, especially given the fact that they are going to be scheduling everybody for interview. If my marriage is not working, how do I remove the conditions of my 2-year green card? You can file based on divorce. If you start by divorce proceeding, start the divorce proceeding, as long as you have enough evidence to show that it was a good fit marriage. If you've been the subject of subjected to abuse, then you can file based on abuse. If abuse or divorce doesn't apply to you, then you can do extreme hardship. I want to believe the spouse is still alive. Need like at this point, but if someone loses a spouse, then death is another waiver ground. But if none of those three apply to you, then extreme hardship is a waiver ground that you can file on. Okay. Case approved 2024, waiting for green card, but VAWA and green card sent back to Vermont. I'm worried. Okay, so what's your question? Learned a lot from your program. Thank you. After how many years can one get a green card if married to a citizen in the military? After how many years can one get a green card? You're not just going to get a green card just because you're married to a citizen. You have to apply for the green card. Okay. All righty. Okay, everybody. Based on this administration and his U visa pending at any risk to, but there's been a lot of talks about cancellation U visa and all that. There's nothing that I know as of today. But your case being admin closed and your U visa still pending, I think it's just leave it as it is. Yeah. Okay. Hello, Miss Itola. How are you? All right, people. Let me go. Put my head down somewhere and go rest. And 𝒊𝒎𝒏𝒕, I was almost thrown out of court this morning, and that's just normal for me because criminal court gets heated, and you already know. You can take the girl out of Nigeria. You can take the Nigeria out of the girl. Thank you. Yeah. So, but all in all, God remains God. God is still God. God remains God. God is still God that sits on the throne. Even when it seems like everything around you is falling apart, let me remind you, if you hear nothing else, if the immigration thing is not even what you're worried about and all that, but hear this, that when it seems and appears that nothing is working in your favor, that doesn't mean God has stopped working on your behalf. So you may not see things may be like, okay, it's not making sense, it's so stormy, but peace be still, keep calm, because God is still working in your favor. He's still working in your favor. Hello, Miss Amosu. He's working in your favor, and he will perfect that which concerns each and every one of us. I'll see you guys next month. Yeah, because it'll be next one by the time we see you again. Have a wonderful weekend, everybody. Bye.